This is Tomasz Gruszkowski at the IFLA Preservation and Conservation Center at National Library of Poland. Welcome to the fourth webinar in series on digitization projects. Today we tackle the legal issues.
So good morning. My name is Melissa Levine. It's maybe afternoon where you are. I want to thank Tomasz and Maya for both this invitation to speak with you and also to collaborate with Maya in particular. Tomasz was just saying that he felt that his copyright knowledge was very, shall I say, essential. And one of the things that I find, I've worked in this area of cultural heritage and copyright and related issues like contracts for over 30 years. And I realize I am an expert. However, I am always learning. So there's not sort of an end to the education process. So a quick overview of what I'm going to discuss for the next few minutes. I'm going to give you a very basic explanation about the structure of American copyright law as a scaffolding, and discuss some of the key limitations and exceptions, particularly fair use in the American context. I'm going to discuss a set of tools and a project called rightstatements.org, which some of you may be familiar with. It's a very useful tool. And I'm going to review some practical details and share documents in our resources for the way in which we approach planning for digital collections at the University of Michigan, which has been involved in digitizing since certainly the mid-early 90s. That process evolves over time, and I look forward to talking with you about that. And then Maya will take over and discuss the EU context in more detail. So what is intellectual property? This is one of those fraught phrases that's very convenient, but when lawyers talk about intellectual property, it's sort of a bucket that includes copyright, trademark, patent, and generally trade secret, which are four different interrelated but different areas of law. So today we're focusing particularly on creative expression, that is copyright. So American copyright emanates from our Constitution, from our founding documents. It was viewed as something that was so significant and so important in the formation of the legal structure of the nation, even in the late 1700s, that it's embedded in the list of rights and responsibilities of our Congress, our legislative body, to regulate. So this expression that is in Article 1, Section 8 of our Constitution says that the Congress has the responsibility to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And just to give you some orienting, we have our Constitution, and then we have the laws that are issued by Congress, and those are called the United States Code. So Chapter 17, it's almost like, think of it literally as a chapter in a book of the United States Code, is our Copyright Act. So what is copyright? Many people use the metaphor of a bundle of rights. The law lists a number of affirmative things that the copyright holder can do or delegate to others through licenses and contracts and other kinds of relationships. So it includes the right to reproduce a work, distribute a work, prepare derivatives, say things like translations, perform or display, or license to others. So the way I like to think about copyright is if you're the copyright holder, you have a monopoly, and many rights holders view themselves as having the metaphor of the whole pie. They have all the rights. But copyright holders actually have the whole pie with a slice taken out. Even though you've created something, there's a piece that's reserved for the public good. So this slice is the limitations and exceptions. These are the things that are right from the beginning of creation, which is not entirely intuitive, do not belong to the creator. So there are certain kinds of users' rights that are embedded in American law and law of many other countries. So how long does copyright last? How does it start? Copyright exists today from the moment of the expression is fixation in a tangible medium of expression. The work has to have a modicum of originality, just a little bit of originality. Typically, copyright lasts for the life of the author plus 70 years. You all are probably familiar with that formula. In the United States, we had what are called formalities, meaning registration of a work with the United States Copyright Office in Washington, D.C., which is located in our Library of Congress. This is similar in other countries. You're required to provide deposit copies for the national collection. And you also, in the past, had to make a copyright notice. In other words, that C in a circle, or one of the versions that you see on the screen now. It's the copyright word or abbreviation, the name of the rights holder, and the year that you're asserting the right. In the United States, when we joined the international treaty, the Berne Convention, we had to make some adjustments to our copyright law in order to meet the thresholds of that treaty and to get the benefits of that thinking of a treaty as a contract in a sense. So today in the United States, you do not need to have notice. You do not need to register for a copyright to exist. However, you do need a registration in order to bring a suit for infringement, which is important to know. So, as I was keeping in mind that pie metaphor, what does copyright protect, and what's outside the scope of copyright entirely? So, copyright generally protects things like writing, choreography, this is very tricky, music, visual art, film, architectural works. It's not there is a list in the law, but it's not an exclusive list, so that if there are other kinds of creative fixed works in other mediums that are emerging, those might be considered ineligible as well. But the law also includes a list of things that are not eligible for copyright. And it really does make sense. Copyright does not apply for things like ideas, facts, titles, data, or useful articles, inventions, or things made by animals and non-humans. And you may be familiar with the lawsuit involving Naruto, the primate, who took some pictures, and there was a whole discussion about whether this non-human actor understood the activity well enough. And there's a whole interesting conversation. It seems like something that's peripheral to think about whether animals have copyright, but a lot of the arguments and discussions also apply to considering the same things for artificial intelligence generated materials. So ideas, the law protects the productivity of something that's fixed in a tangible medium of expression. So I suppose, arguably, this recording is not just me speaking my ideas, it is actually being recorded. Now, whether Tamaz has the copyright or I have the copyright, or how we would organize the rights, say, in this video is actually a really interesting question. The way we sometimes think about ideas is the story of star-crossed lovers like Romeo and Juliet is a broad enough trope in Western and other cultures' storytelling that the particular expression, whether it's a book, whether it's a film, of that dynamic, that's the piece that's protected. But I can still write a story today about sort of a Romeo and Juliet kind of character, and it's the idea of that is fluid, and that supports that constitutional commitment to that phrasing of we have copyright for the progress of science and the useful arts. Facts, if we could If you think of copyright as a kind of monopoly, if there was an exclusive monopoly on the number 3 or the letter Q or the title of something, it would make it very difficult for us to innovate. We need these, there are some common building blocks that are oxygen for all of us in terms of building and rebuilding those pieces. So those are all excluded. So who has the copyright and how does it arise? Okay, so in the United States, generally speaking, copyright exists from the moment of creation. So if I write some notes and they're sufficiently original, I have copyright in that from the moment I created them. Those copyrights, depending on the nature of the creation, film, book, might be transferred or assigned to some third party through a license or contract, depending, and the form of that typically will depend on the industry in which you are engaging. There's a lot of business practices that intersect with copyright, and those are different by industry and also probably by country and region to some degree. So that works when you have one creator. Sometimes, frequently, you have two people or more working together to create something. Under American law, our approach is that each person, even without a contract, participating in that creation holds copyright equally and jointly in the work. Everybody has equal rights in the work unless there is some agreement otherwise. This is a really important piece to think about if you're working in a collaborative environment. The main condition of this is that if any single rights holder uses or shares the work in a way that generates revenue, they are required to give what's called an accounting. In other words, you have to share equally any of the proceeds. So joint copyrights tend either to be very not well thought out or highly negotiated and subject to contracts depending on the nature of the relationships. The other concept to think about in terms of who has a copyright is you may have heard the expression works made for hire. So generally these are creative works that are made by people within the scope of their employment. And in that case, the employer under American law typically holds the copyright. So if I work for a company and my job is to write technical guides, I do not hold the copyright unless there's a special arrangement. I'm hired, let's say, as a writer and a technical expert, and my company owns the copyright in my work product. This is a little bit different with independent contractors. So if a company hires someone with special expertise, typically, who works independently, who does not have a tremendous amount of oversight from the contracting party, the company, the independent contractor, let's say it's a graphic designer, they hold the copyright in their work, again, unless there is a contract that describes the relationship and how the rights will be addressed in advance of the work. So I know it's different in different parts of the world, but it gives you the general sense of the ways in which copyright can be held by the creator, by an employer, by an independent contractor, and so forth. If you are in an academic environment, so I work at a large university, one of the things that we see that sometimes causes a little bit of conversation is the way in which different disciplines identify people as authors for the purpose of copyright purposes versus authorship and intellectual credentialing. So in many of the sciences, if you look at the list of authors to an article, it can be very long. Only one person, probably the lead author, has signed a contract or a license with a publisher to publish that. And there's a little bit of a confusion about whether every single one of those authors would in fact hold copyright or whether this is really a credentialing, a very important, but a credentialing exercise that's a little less intersected with copyright. It's just an issue to be generally aware of if you're working on a university campus. If you're in a cultural institution and you're thinking about a digitization project, another thing you may be looking at is are compilations. So compilations are many pieces brought together. So it could be many chapters in a book. It could be the way in which, say, a newspaper or website incorporates many different kinds of images, written material, maybe video. They could be all created by one employer. I'm not even aware of that really existing very much anymore. You have rights that are complicated and they multiply across different kinds of works. So even if you're looking at preservation for one film, there probably are many different kinds of rights holders. In the business practice in the United States, if it's a commercial film, typically a producer is sort of the business manager. And in addition to contracting for all the talent and the space and so forth, part of what they obtain typically by contract are the rights in the film so they can distribute that in its entirety without having to renegotiate rights over and over again. This is really tricky. This is an old metaphor, but one that I particularly like. I don't think it's used very much anymore. Evaluating the rights in the compilations is like boiling the ocean. It's not really, it's very difficult to feel fully satisfied in terms of how one is breaking out all the different rights components and these kinds of things. And it's one of the reasons we're going to talk about limitations and exceptions further in Maya in particular. It's one of the reasons those carve-outs, that piece of pie, would benefit us as cultural institutions to make this piece of work that is very much within our mission, particularly the preservation and certain kinds of access, more straightforward. So one of the other things that I want to mention that is corollary to copyright is that it's important to understand where you work and what the work product, what you're trying to accomplish. So I pay attention to our federal laws. I pay attention to laws in the state of Michigan. So this is analogous to being, say, in the European Union versus an individual country within the European Union. And then we have policies, written policies that direct our work within the university campus. So I'm an employee. So if that were the end of the relationship, the works that I produce, say this video or this presentation, would be held by the University of Michigan as my employer. By policy, we have a written policy that says that faculty have copyright in their scholarly works. There are certain administrative and preservation rights carved out for the university, but this is a policy choice. So if you are a faculty or student of this university, you hold copyright, say, in your classroom work, those kinds of things. If I were working in, say, public relations and writing press releases and that kind of thing, but I'm not a faculty member, librarians are faculty at this university, then their work would be work for hire and held by the university. One of the reasons that we have these distinctions is that holding copyright is the power to censor. So if I'm doing scholarly work, and for whatever reason my university doesn't approve, if they held the copyright, they could censor my work. And this is one of the reasons academic copyright is tremendously important, and thinking about how that is shared is significant. So upshot is I want you to be aware of the policy, the practice, the legal status of your organization, because that may also shape your assumptions and decisions. The other thing that comes up in my work is a lot of confusion between plagiarism and copyright infringement. So infringement is a legal concept, and it deals with the unauthorized reproduction or the use of one of those threads, one of those sticks in the bundle of rights I was talking about. One can infringe intentionally, which can have criminal consequences, or you can just be negligent, like you didn't realize, or that kind of thing. Plagiarism is not a legal concept. It is reproducing somebody else's work and calling it your own, and it's obviously important to have citations and reference the scaffolding of your own work, your own expression. It can be very sensitive in the dynamics between multiple people collaborating on a particular work. And you can have one of these things or both of these things, but they're different. And students and faculty often get these conflated with each other. So I want to, my next comments touch on some of the things that we've talked about already, but to remind you, to be protected by copyright, a work has to be original. It has to be independently created with some spark of creativity. So if two people in different parts of the world come up with sort of the same idea and express it in some tangible, fixed medium of expression, there may be actually two copyrights. There's no protection for ideas. The expressions, the fixed expressions are protected, but not the ideas themselves. General themes, like I was talking about the Romeo and Juliet concept, or one expression I've heard is Viking, the trope of a Viking ship in a Viking movie. Like, that's not a copyrightable component. Things like procedures, processes, systems are not part of copyright. Those are part typically of, they're either not protected at all, or they can be in the space of patent. Basic graphs, charts, things organized alphabetically, certain kinds of diagrams like bar charts. They may be expressing data that in and of itself, each unit is not eligible for copyright. Put together as a compilation, certain compilations, it might be eligible for copyright. But it also may simply be an expression of facts. So a bar chart that expresses some kind of numerical overview may actually not be eligible for copyright. If it's not eligible for copyright, or it's not otherwise protected, it's free for others to use. So part of that free for all to use, and part of that carved out slice of that pie are works that are in the public domain. And this simply means that they are creative works that are eligible for copyright, but for which copyright has expired or doesn't exist. You can, as we noted, the typical term of copyright today is the life of the creator. I should mention that if you have several creators, a joint work, that 70 years lasts from the date of death of the last surviving author. Once works are in the public domain, I can affirmatively put a public domain mark on my own work. I can assert that I'm making this thing and I'm placing it in the public domain. That loosens it up for others to use and reuse. So there can be an affirmative statement of some sort. If something is in the public domain, anyone can use it. There's no legal requirement for attribution or copyright restriction at all. However, citation and attribution are appropriate, particularly in the academic setting, for reasons that are distinct from legal requirements. I should update this date. Works published in the United States before, I think it's 1927 now, are in the public domain. And for when the United States extended its term in the 1990s for copyright to level up with what the European Union had shifted from a life plus 50 to a life plus 70 formula. The annual advancement of works entering the public domain in the United States stopped for a very long time, sort of catch up, as it were, with the additional term of copyright. So up until fairly recently, that 1923 marker was fixed, but we are now moving forward in time, happily. In the United States, this is an interesting fact. The Copyright Act says that works produced by U.S. government employees are in the public domain. They're free to use within the United States. So if you have a collection with lots of federal works, most of it's probably in the public domain. Again, like everything else, it could be complicated. There could be photographs that were commissioned by an agency, and the rights may be held by the photographer or their descendants or licensees. You can have works created through grants, and there could be grant contract provisions that govern this assumption. But as a general rule of thumb, works created by federal employees, not state employees, it's a different situation. So I do not know if there are analogous considerations in your countries, which I wanted to raise this, even though it's probably not directly relevant in terms of American works for many of you. So the key exception within American law, and we have a whole series of exceptions that are written in our law that's part of that pie that's carved out right from the beginning. There are, if you have a fair use, it's one of these specific situations where someone can use a work without permission from the copyright holder. And so the examples of the kinds of things that you would that would be eligible for fair use typically are things like commentary, criticism, parody, news reporting, research and scholarship, use of content, use of copyrighted materials in a search engine, as a search engine, not as access to the work itself necessarily. And these are very tied up in, again, the progress of science and the useful arts. If you could prevent those kinds of uses in their entirety as a copyright holder, you can engage in a form of censorship. And this is a provision that aligns copyright with our First Amendment and our speech principles in this country. So first, you have to look at the nature of the use, this umbrella of, is it criticism, commentary? Is it one of the kinds of uses that would be eligible for fair use as a policy and practical matter? And then you look at four equitable components. These were built, the 107, which is the section of the Act that addresses fair use, was added to our Copyright Act in the 1970s. It was based on an evaluation of, say, a century worth of legal opinions where a judge would look at a particular situation and say, this particular use is an infringement. However, it's necessary in order to engage in those First Amendment protected rights. So there's no damages, or there are minimum damages. The people who were updating the law in the 1970s looked back at all those cases and synthesized sort of the key elements that had been developed over the century, over the years. And those included the purpose and character of the use. So, for example, is it a commercial use or is it a nonprofit educational use? The nature of the copyrighted work. Is it fiction, like a novel, which tends to be more protected and less eligible for fair use, but it really depends on the specific circumstances? Or is it a factual evaluation of something or a straight description of something. So even though there can be a great deal of effort and training involved in writing those descriptions, they may be, if they're geared towards describing in a factual way some situation, that might be less eligible, you can have a copyright, but there's an expression, it's a thinner copyright. The third factor we look at is the amount and substantiality of the portion of the copyrighted work on the whole, and the effect. The fourth is the effect of the market for the copyrighted work. I'm looking at my time, and I think we should skip to the slides on. I was going to talk next a little bit about open access and open licenses. I think I'll pass over those. You'll have the slide deck, and let's go to the right statements slides. So this is the second part of my presentation. These next two pieces are fairly short because I mostly want you to be aware of them. Rightstatements.org was an initiative that I participated in. It started around 2014, and libraries and increasingly museums and archives have been digitizing materials since roughly the mid-1990s. And in the United States, because we have fair use, we have a lot of elasticity that allows us to digitize works and make them available as libraries and archives in a way that is that in most parts of the world need an affirmative legal assertion, a legal right to make those copies. So we started, some colleagues from the United States and some colleagues from Europeana were discussing this and developed these rights statements. And partly we were trying to address this kind of issue. So this is an example of a rights statement on an American library's website. It's a lot of information, and it's sort of not really helpful information. You also see metadata like this expressed a certain way. Helpful, not that helpful. And many of the people involved in forming the rights statements framework were heavily involved in Creative Commons. And we discussed early on the way in which this is distinct from Creative Commons licenses. If you're not that familiar with Creative Commons, it is a nonprofit organization that develops open licenses that are legally usable and can be applied to express a license, an open license for use and reuse of materials. But you have to be the rights holder to apply those licenses. And typically, as cultural institutions that hold materials in stewardship, we are not necessarily the rights holder in, say, a particular book in our collection. So we started to try to develop a way of describing rights status as best we could, and having a stable set of URI to describe those things. And we were looking for a framework that was simple, flexible, descriptive, active, accurate, and transparent. So the rights statements do not add new rights. They're descriptive. And part of the principle is that we are stewards, we're not gatekeepers. We want people to use and have access to the materials. And we're relying on organizations that implement these to be as accurate as possible and make good faith descriptions so that people using our online collections can use and reuse those materials. So very quickly, we have a number of variations and these labels, these icons that can be used in the system. And big picture, broadly, we have the categories of in copyright, no copyright, or other. And other can be a range of things. So we have several different flavors, as it were, for in copyright works. In the EU, there is actually law dealing with orphan works and ways to use orphan works. We do not have that in the United States. We rely very heavily on fair use and other exceptions for that. We have several flavors of ways of describing works that are out of copyright. And there's several, this is where we have several flavors of we don't know. And even that is a helpful indicator for users. So I wanted to share very briefly an approach to the University of Michigan Library. I mentioned our organization because University of Michigan has been digitizing collections since at least the early mid 90s, and was one of the early institutions to start to engage in this work. And I worked at the Library of Congress in the 90s and developed a process for reviewing collections and documenting collections there, describing them online. And this digital I'm sharing this website, which is in the resources, to give you a sense of this. I worked with my colleagues in technology, the many different skill sets and expertise you need in an organization to actually digitize it and make collections available. Originally, I had a very detailed set of questions that we would ask curators or librarians or other collection stewards to fill out if they were digitizing, if they wanted to propose to digitizing a collection. We found that people were overwhelmed, and they didn't actually provide very much information because they didn't understand where it fit. And I found that it was more efficient to sit down with people and understand the materials and functionally talk through this list than asking people necessarily to fill it out by themselves. But that's hard to do at scale when you have many collections in process at the same time. So we combined sort of the factual questions that I need for a legal analysis with all the other technical pieces that are needed to evaluate a proposal in general. So people are answering questions I need to make a copyright assessment or to provide guidance, but from their perspective, they're just providing factual information, and it's, I think, been successful in minimizing the intimidation of collecting the information we needed. So there is a link to our digital project proposal sample. It's probably, many of you probably have similar kinds of documentation. This is one of many. It might be useful for you, it might not be. But I did want to share it because it does help organize ideas. It's helped immensely with workflows and project planning and execution. It helps us tease out unanswered questions. It's been useful for us as a large organization. This library, to my astonishment, has about 500 employees. But we had a similar process for the Library of Congress, which has several thousand employees. But the same process is useful if you're at a small organization. It helps develop not just a way of approaching workflow, but having documentation on record. The way I like to think of it is for the future me, so that we are hopefully minimizing issues of orphan works by better documenting what we're doing today. These are elements. I just listed them here rather than sharing the slide, which is an open form document. These are additional elements, and the last time we revised this was 2021, so we'll refresh it. But you can see the way in which the factual information in the first slide can help with a legal analysis, and we shift into things that have to do more with the technology as well. So here are a few of my resources. I think Tomas has also provided them in additional format. I think we're done. So I'm only 4 minutes late. I'm going to turn my camera and microphone off and hand this over to Maja.
I'll just tell you that I will be putting those resources in chat right now, and I'm switching giving the floor to Maja.
Thank you very much. I kindly asked Tomas to put on my slides. Before Tomas is starting to share my slides, I want to thank you to Tomas to inviting me to make this presentation together with my dear colleague and dear friend, Melissa. I had the pleasure to be a host of Melissa and her amazing copyright team at Michigan University back in 1919, before COVID. And I had a wonderful experience in a snowy, stormy Ann Arbor at that time. I was so impressed by the work that Copyright Office of the University of Michigan does, that since then I have this idea to bring something home to Slovenia. So saying that, I'm like totally excited that there are some participants today also from Slovenia. Damiana is there, and I hope somebody else as well. Why I'm saying this? Because I'm really serious about this devotion to build some sort of system of providing legal advice, training, and legal information to digitalization and other projects that libraries or other cultural heritage institutions under the scope of university and research institution do on a larger scope. Slovenia is boutique, I like to say boutique country. We are only 2 million, so the idea that I already presented to some libraries here in Slovenia would be to build like one center like this that would be able to provide the information. And I always refer, when I talk about this idea, I always mention the center, the Melissa Center at Michigan University, and I really want to inspire to do something very, very small and on a different organizational manner, but something like that. So basically, I'm a lawyer by education, and I'm a founder and head of the Intellectual Property Institute, which is research, consultancy, and training institution here in Slovenia that provide legal information and advice on this topic. My specialty is intellectual property and lately also data governance and artificial intelligence, but in intellectual property, I'm most focused in copyright, in particular on public interest in copyright. That means that I am interested to study and research and present on exceptions and limitations, and also like legal protection of technological measures in copyright. And so why I do that, of course, my natural partners are libraries, researchers, educators, who are provided exceptions and limitations in our copyright law. Saying all this, I will first explain what will be the focus of my presentation. I have a luxury to present after Melissa's presentation, so I will just assume that now you all know the basics of copyright, and I will not repeat those. I will just mention that copyright law is largely harmonized, is very harmonized across the globe, but the rule is that copyrights are still territorial. So in Slovenia, the Slovenian copyright law applies. In Germany, German copyright law applies. We don't have European copyright law. We have European legislators who try to harmonize European copyright law through instruments that they have, and the European legislators currently have two kinds of instruments. One is directive, which directs to member states how to implement their law, and the other instrument is regulation, which is directly applicable all over the European Union. And in the field of copyright, we only have directives, which means we have European directives, which then European member states need to take home and implement in their national law. So today I will focus on the new EU Copyright Directive, which is the main instrument for this audience that is listening to this presentation today under the scope of EU copyright reform. The EU copyright reform started in 2016, or some people say that European Union is constantly reforming its copyright law, but the most recent EU copyright reform started in 2016 and resulted in the package introduced in September 2019. And the most important legal instrument for this audience was the directive on digital single market directive, which is also called on copyright and related rights in the digital single market, which is also called shortly DSM directive. And this was implemented in April 2019, and member states needed to implement this directive by June 2021. In many countries, this did not take place. And recently, at the end of May, Commission sent reasoned opinions to 13 member states, and Slovenia is among them, warning them that they need to implement this directive as soon as possible and no later until the end of 2022. So we expect that at the end of this year, all member states will implement this directive. As I mentioned before, this is directive, so it only in a way directs or dictates to member states how they need to change their copyright acts. So at the end of the implementation, when all member states will implement the directive, we will still have different copyright systems that will be more harmonized. This directive is not the only one who deals with the exceptions and limitations for copyright. We have the old so-called InfoSoc directive, which is now more than 20 years old. And we also have the Orphan Works directive from 2012. InfoSoc directive already had some mandatory and some less mandatory or non-mandatory exceptions that member states needed to implement. Some of them were specifically targeted for cultural heritage institutions and were useful also for researchers, educators, and libraries, museums, galleries, and archives. There was an optional exception and limitation for illustration for teaching or scientific research. Another one for uses for the benefit of people with disabilities, and another one for the use by communication or making available for the purpose of research and private study in specially dedicated terminals in establishments, meaning in public libraries, public archives, and research and scientific institutions. That's not the complete list of optional exceptions and limitations, but the most important ones, but were not mandatory. So member states decided through political process whether to implement that those exceptions and not. For example, Slovenia implemented exception for education, but not exception for scientific research. And many other member states did not implement any of those exceptions or implemented just exceptions in a different manner. Bottom line is that European digital single market, or not even digital single market is not harmonized regarding the copyright. So there was a huge pressure from different institutions to resolve this situation and introduce new exceptions and limitations that would be better harmonized throughout the European digital market. Before I move further, I want to specifically mention again the Orphan Works Directive that already Melissa mentioned. Orphan works are works that we know that are still in copyright, but because there is no requirement for formalities, meaning there is like no registry about who owns the copyright, nobody knows who is the owner of copyright. So, for example, many museums keep many photographs, and nobody knows who is the copyright holder of those photographs. But there are also paintings, books, and so on. So, and with the massive digitalization projects, suddenly for the research or educational purposes, it's very beneficial to digitalize those copyright works as well, and preferably to put it online. But it's a fact that they are still protected by copyright, but nobody knows who the copyright owner is. And we call these copyright works orphan works. And of course, there was a huge pressure from libraries, archives, museums, and galleries to design a regime that would give some better options for those institutions to digitalize and put online works that are obviously still in copyright, but you can't find the owners of copyright. The directive for orphan work complicated or installed a very complicated process for diligence search, and many cultural institutions across Europe say that this directive does not work very well, or in the forms that the member states implemented. For example, I worked for many years with the National Library here in Slovenia, and they didn't digitalize one single orphan work and put it online, because this process that was introduced by Orphan Work Directive is too complicated for them to apply. And the situation in other member states, it's really not much better. There was a study conducted 2-3 years ago. I can't count anymore because of this gap of COVID. And I know we discussed that in CNL, which is a conference of in the working group for copyright of the national libraries. And there was like rarely that orphan works offered some good legal instrument to resolve this problem. But anyway, we have this directive. It was implemented in better or for better or worse in many legal orders of member states, but it's not really effective on the ground. So, as mentioned before, in 2019, there was a new directive introduced, and before June 7, 2021, member states were supposed to implement this directive. And what is in this directive that is really important and useful for research libraries and cultural heritage institutions? There is a provision for text and data mining exceptions, and there is a new exception and limitation for text and data mining. There is a new exception for preservation. There is a new exception for out-of-commerce works. There is a new provision that regulates contractual override and technical protection measures. Specific provision on the public domain for works of visual art, and specific exception and limitation for education. I will talk about these exceptions in more detail. Before I do that, I said before that I'm not going to explain the basics of copyright in Europe. Copyright as a legal system is very, very much harmonized throughout the globe. Berne Convention, which is older than old peace conventions, did this job. We got Berne Convention when when works protected by copyright started to move around the globe. So when they changed from one country to another country, then there was a need to harmonize the copyright systems, that book written and published in one country would be protected in another country as well. So, and because of this Berne Convention, which provides the minimal standard for protection, the general legal system, the copyright system across the globe are very, very much harmonized. So the copyright systems of European member states, so Slovenian copyright legal system, German legal system, French legal system, is in many aspects harmonized by the US copyright law that was presented before by Melissa. But of course, there are some differences. And at this point, before I go to these exceptions that are provided now with the directive that the countries need to implement, I would like to mention, and I don't have a special slide for that, which are the main differences that that are worth mentioning. So when Melissa was presenting the basics of copyright, I wrote down what I need to tell you that you will be able to rely to Melissa, but have on your mind where are the difference. One thing is that Melissa said that that the works, when are created, expressed, and fixed, deserve the copyright protection. Of course, if other conditions are fulfilled. The European continental copyright law does not require fixation. So if I go on stage and I present and I lecture, my presentation is already protected. In US, it needs to be fixed. In European continental legal systems, it's enough that it's expressed. So that would be one big difference that is still applicable today. The second thing is it's not applicable to date anymore, but it still has some important influences, is that in European continental system, there was never a requirement for formalities. So immediately when the work was created and expressed, the author gained copyright protection on that work. So there was no need to put on the coat and go to registration office and register. Never in the history of copyright law. But this is due to bigger protection of author. But the side effect of this system today is that we have many, many orphan works because we have no idea who is the original owner of or original creator and then owner of copyright, who was or who is today. The third difference is the fair use. Melissa was explaining this concept, and that was designed by the court decision and works very well because it's flexible and it's not so that when the new cases of fair use arrive and the four conditions are fulfilled, this is already like a defense for these uses in copyright law system. In European continental law system, we do not have the fair use concept. We have exceptions and limitations. So our legislators took the recipe from the Berne Convention, which designs instruction for legislator how design exceptions and limitations, and they designed special exceptions and limitations in our laws. So, for example, the copyright law in Slovenia has special exception for parody, special exception for quotation, special exception for news reporting. We don't have special exception for text and data mining. So we don't know, or we have like huge legal uncertainty before the new directive will be implemented about text and data mining uses in Slovenia. And the same is, or similar is in other European member states as well. The fourth thing that we also don't have, or maybe some legal system have, is the concept of work for hire. In European continental system, the creator is the owner, is the original owner of copyrights. There are some legal systems that have this assumption that although the original creator first gets the copyright protection, there is then legal assumption that these copyrights are transferred to a legal entity on the legal assumption based on law. In Slovenia, we have this sort of system. In many other member states, they don't have this. So these four things that I want to mention that you will be, that also all of you that come from Europe can rely on the wonderful explanation of Melissa, but be careful about these 4 special things that I just mentioned to understand that there are some difference between these two systems. And again, we don't have European copyright law. We have Slovenian, German, French, Swedish, and so on. Now I will go deeper in these 6 exceptions that's my task for you to. I don't speak English anymore. It's my task today to present these 6 exceptions. So first, about text and data mining. So text and data mining is activity when computers enter the library and read all the books and find facts and ideas in those books. It may be reproduction, but of course, because they are looking for facts and ideas, it's not very clear whether we need to have a special exception and limitation, whether this is no reproduction of, or it's not bigger than reproduction and facts and ideas. So at the beginning, it was a huge debate whether we need this special exception or not, but it was agreed that there is a legal certainty. There is legal uncertainty, so no legal certainty for researchers and all others that are involved in this data analytics. So there was this need to provide for new exception or limitations, that researchers will be sure that this activity is allowed under European copyright law or the national legal system. The European legislator provided for 2 new exceptions. In Article 3, it's a mandatory exception for researchers and for all those who have legal access to open web and to the collections of universities, libraries, archive, and other cultural heritage institutions. So it needs to be, TDM needs to be done for research purpose. It can be commercial or non-commercial, and the access to the materials is provided through open web or through the collections, which in theory means if the library buys material under a license, then their researchers are allowed to do text and data mining according to the new directive. And this is very important that in this way it is implemented in the national laws, and the owners of copyright cannot prevent this. So it is mandatory exception, and you cannot take this exception away by contract. This is like really, really important. So if one library now buys the collection, it's no need to buy a special permission to do text and data mining when this this exception will be correctly implemented in national system. I want to mention also Article 4, because that's a general mandatory exception or limitation for general public, so others than researchers. For these purposes, the owners of copyright can prohibit. They can expressly prohibit that for this sort of purposes, other general public, so others than researchers, need permission. So it's a huge difference between these two. For this audience, I assume it's more important Article 3. The other exception that is now introduced by the DSM directive and the member states need to implement is preservation exceptions. Not all member states in Europe have this exception, so of course this can inhibit preservation copying and can inhibit also cross-border collaboration. So to resolve this problem, the new directive introduces this preservation exception. So under new Article 6, when it will be implemented in the national legal system, the copying and extraction from databases will be allowed. Publicly accessible cultural and heritage institutions will be able to do this. And all the works in permanent collection at any point in their lifespans. There is some debate about permanent collection because some even national libraries, they have collections on loan from state or something like that. For example, Austrian National Library. So there is is it enough to have long-term loan, or it needs to be permanent? So there are some issues there. And you can copy as necessary for the purpose of preservation, it's no restriction with the places and technology, and of course it is essential that this exception is without remuneration, and it covers, of course, cross-border uses as well. But of course, in this Article 6 that is in the directive, it will be all, the end result will depend on the way that member states will implement these exceptions. And member states can go further than just do copy, translate, paste of Article 6. An additional provision that's extremely important in this directive is that it specifically regulates that contracts can not override certain exceptions in this directive. This provision does not include all the exceptions, just some of them. But of course, again, member state legislators can go a step further and enact that contractual override or override by technological protection measures should be prohibited for all exceptions. So Article 7 regulates this, and this article is mandatory applicable for text and data mining, for educational exception, and for preservation. So in these three cases, the European legislator says these are mandatory exceptions and should stay like mandatory and applicable and cannot be overridden by contract. So even if one library signs a contract and say, I will not use this collection for text and data mining, that provision would be null and void, because you cannot take away the exception by contract. So, and it's regardless whether this would be contract by European subject or contract by non-European subject. In any case, for European researchers, text and data mining, the same as educational exception and preservation, is now mandatory and cannot be taken away. I am looking at time. I will conclude with all the exceptions and then as quickly as possible. Additional exception is also very important for out-of-commerce works. I mentioned before that orphan work directive does not really work very well. So maybe better solution for out-of-commerce works is this new exception, which is introduced in Articles 8 to 11. And so it's, member states are required to provide a legal solution to allow cultural heritage institutions to digitalize out-of-commerce work and to make them available. One is a licensing mechanism, and the other, in case when there is no collective management organization, then as long as there is no collective management organization for a certain group of works that would have a mandate to collect and to license, then exception applies. So this means that out-of-commerce works can be digitalized and put online, but when the collective management organization will be organized and will get a license, then this should be done through the licensing mechanism. It is also very important achievement for the public domain in Europe that directive has a special provision for public domain. This is important for the sake of public domain because it's written for the first time in legal regulation that public domain should be respected. Why is this important? Because of the cases like Spanish museums claiming copyright over paintings by Dutch masters who have been dead for 350 years because they reproduced those paintings. Or German museums suing Wikipedia for hosting reproductions of public domain works as part of Wikimedia Commons. German museums claiming copyright on reproductions, meaning photographs of those works. So next slide, Article 14 tries to solve that. So it requires member states to change their laws in order to make it clear that any material resulting from an act of reproduction of public domain works of visual art shall not be protected by copyright or related rights. And this applies specifically for the public domain works of visual art, but legislator can go further. Conditions are that the original work is not copyright protected anymore, and that the reproduction material is not itself original. Some photographs can still be original work of art, but this is for these specific reproductions. Exception for education. It resolves problem of legal uncertainty because of cross-border projects. It is specifically targeted for educators, but of course also cultural heritage institutions do education. So it would be very important that that this exception would apply to them as well. It would be very important that implementation in member states does not give priority to licenses, does not require compensation, does not enact quantity limitations, that it would be very broad definition of secure electronic environments, and that all kind of uses in educational practices would be included, and any individual, not just teachers or pupils, but also maybe parents, and of course, as I said before, that GLAMs, which stands for galleries, libraries, archives, museums, or cultural heritage institutions would be included as well. So I briefly mentioned what is in the copyright directive. Of course, every exception that was mentioned could have its own webinar that would last 2, 3, 4 hours or even 1 week. The European legislator is doing its best, or I'm first. European legislators, because there are more, want to harmonize the European copyright law. Are they doing well or not? Probably it's better to have exception for public interest institutions than not. So they are taking care about digital single market solutions. When we look at the global situation, European legislators or European institutions do not work very hard to bring those exceptions that identify that are useful for digital single market, to bring them to global level. The global discussion about the copyrights on one hand and exceptions on limitation on the other happen at WIPO, which stands for World Intellectual Property Organization. Currently, there is 42nd Committee for Copyright and Related Rights taking place. There was a session in May. African members presented a proposal that would put back on the agenda limitations and exceptions to copyright, especially for libraries, archives, educational institutions, research institutions, and persons with other disabilities. Many of these exceptions exist in Europe, but now we are talking about the global harmonization of those exceptions. In 2018, a civil society, TIS, more organizations organized and proposed treaty on copyright for education and research that would address specific exception in this field. So many things are happening, but as is well known, the member states that are the strongest at WIPO and are big exporters of works protected by copyright do not see exceptions and limitations as favorable instruments to a balanced copyright systems as public interest institutions see. So there is a huge political tension in that area. But it's very important to follow what's been there, especially if you are from countries that are members of WIPO, because sometimes you can work very, very good for the sake of your institutions. For the end, because I'm really running out of time, next slide, please. I just want to mention also Communia's new recommendations. I'm a member of Communia. My Institute of Intellectual Property is a member of Communia, and I sit in the administrative council of this wonderful institution that predominantly works in Europe but is expanding its activities at WIPO as well. Communia published 10 years ago Public Domain Manifesto and first set of recommendations, and some of them are already embodied in the new directive, but still needs to be done. At the end of May this year, Communia published 20 new recommendations that are basically recipes how to make copyright fit for future, especially from the perspective of public domain. They focused on how to defend and expand public domain, how to protect and promote usage rights, how to empower creators and their audience, and how to create safeguards against copyright abuse. I think, especially for this group, these new recommendations can be really, really instructive and really, really useful. So please consult the references that I'm sure were in the meantime put in chat by my wonderful assistant Sandra. Yes, she did all that. I'll repeat and say thank you very much, first for inviting me, and secondly for listening to my presentation. It was a little bit more abstract, but I realized that the copyright basics were splendidly explained, and they were by Melissa before my presentation. So thank you very much. Tomasz, I give back to you.
I am overwhelmed. So my knowledge about copyright issue went from this to I don't know where, because I don't know where it all ends. But I hope it was your presentations were useful for the audience. And I am sorry that there will be no time for a Q&A, but I guess you do have my email address. And it's still possible to drop me an email, and you've seen Maja's email, and I guess you also have seen Melissa's email. If not, just drop me a line and I'll pass it on to Melissa. The recording of this webinar will be put online soon. And my email address is also in the chat. So I don't know how to express how grateful I am. I am very grateful for your introduction to copyright law. Thank you.